Hello, and welcome to a new edition of NLS Now. This is our Thursday live presentation, and I, of course, am Ray Gertken. Joining us is David. Hello, David.
Hello, Ray. Sorry.
I know, it's every time.
Man's
But of course, today we are going to be talking about the continuation of the CDC moratorium and the new process and procedure for raising a defense under AB 486. So let's get started. David, do you want to talk about the CDC moratorium?
Sure. I think the impetus for extending this, and we've talked about it before, the rent will have to be paid at some point, but there's so much rent assistance under the American Rescue Plan here in Nevada, and it just hasn't been dispersed yet. So I think the feeling of the CDC is let's give another 30 days for that rent assistance to go out and help people who haven't paid the rent. So the CDC is about health. It's not about government inefficiency, but they did extend the moratorium until July 31st. I think they do have some basis based on the Delta variant and the COVID problem that we still face. Things aren't back to normal. The CDC moratorium has been extended till July 31st. There is an appeal. The DC Circuit Court, District Court invalidated the CDC moratorium, but issued a stay. That stay was upheld by the Court of Appeals and by the Supreme Court, or it's pending in the Supreme Court. So my sort of quip was, why would they even address that if it ends at the end of June? I think it still applies for the end of July, but we'll see. The Supreme Court could take action and dissolve the stay. If the stay is dissolved, then the whole CDC moratorium is gone and people are left to their own devices.
Of course, the government did make clear when they extended the moratorium until the end of July that this was the last extension. It's hard saying that. You would hope that if something were to go really badly, things would change, but do be aware that the government did say this was the last one.
Right. And, the more they continue this, the more this is our last warning, doesn't have any credibility, or, you don't take it seriously. But I think people should take it seriously. So, it's not like a parent making a threat. It's the actual government. And I think the discretion, the patience of landlords is wearing very, very thin.
Right. And I think a lot of that has to do with rental assistance not getting paid out, the fact that there is still so much rental assistance available and the backlog of applications, but.
Yes, and all the problems associated with it and the ill-conceived way that they're dispersing it. And again, I think there's a lot of times you can blame government. I think in this case you can blame them, but it's also a lot of people who need a lot of help. So it should take a reasonable amount of time.
And so just in our the last time we talked about the moratorium when it was extended, we made a point that the Nevada moratorium specifically covered no cause notices. It is still our opinion that the CDC moratorium also still covers no cause notices. It definitely covers non-payment of rent notices, obviously, but where the tenant has experienced the loss of income and can positively affirm and attest to everything that's on the CDC declaration, you should be covered from a no cause notice because all of the exceptions to the moratorium are cause related. So go ahead, David. Yeah.
It irks me because when they include non-payment and they specifically set out reasons, exceptions to the CDC declaration and don't include no cause, this is a remedial statute and it should be read liberally to protect people from being evicted. So when you do that, when you act fairly and follow the law, it includes no cause and non-payment notices. And it's a simple, easy argument, but it's not recognized by the courts because they want to favor landlords and they think tenants are being deadbeats because they haven't paid the rent. They haven't paid the rent because they don't have a job, they don't have money, and there's rent
They don't
assistance.
have unemployment benefits.
Right.
Don't
exactly.
forget that. Right. All right. So again, as we advised last time, you know, if you are at all unsure of the status, if you receive an eviction notice and the court state it, or if you received a prior notice and you didn't do anything, call the court, figure out if a case is pending, what the status is. But otherwise, for the most part, as we said, the landlord will likely have to issue a new notice to evict you once the moratorium ends, unless there are some courts that did stay cases pursuant to the CDC moratorium. Those should also be stayed until July 31st. What happens after July 31st, you may need to contact the court to figure out what the status of your case is. All right. Repayment agreements would also still be in effect. So, you know, please remember, if you entered into a repayment agreement pursuant to Directive 36, you know, make sure that you are continuing to abide by those, because that could still be grounds that might be cause for grounds for eviction at this point. All right, and then the mediation program is still up and running. David, I don't know. I think I saw that it expired on June 30th, but I'm not sure if that is accurate or if they're going to extend mediation as well.
Well, it was supposed to expire. I mean, it is related to the CARES Act and the directive, what is it, 41 or 43, and that expired. And the contemplation when Governor Sisolak ended the moratorium was that the CDC moratorium would end 30 days later. So you never want to make any sort of conclusion here, because, you know, the CDC extension was at the last minute and this may be at the last minute, but I think, you know, mediation probably will end at the end of June.
So just keep in mind, you know, you can still try to request it if you've gotten a notice, or, you know, just be protected by the stay, but mediation might be ending at the end of the month. Same thing if you do have an upcoming mediation. If you requested mediation before, just remember that you don't want to agree to do anything you cannot actually do. The CDC should stay the eviction through the end of July. Do not agree to make payments that you honestly cannot afford. There is no requirement that you agree with your landlord or that your landlord agree to a payment plan. So just also keep that in mind, but it is a chance for you to sit down and actually try to have a conversation with your landlord. And of course, you still get a hearing if you don't enter into an agreement. All right, so what happens after the moratorium ends and you get a non-payment of rent notice? What do you do? Or let's just say you get a non-payment of rent notice now because your landlord doesn't care or doesn't know that the moratorium was extended. You need to file a tenant's affidavit to contest the eviction. So for evictions in Nevada, it's a 7-day payment or quit notice. It does have to be served by a process server or sheriff. You have 7 days then to pay the rent, move out, or file an affidavit to contest the eviction. That is 7 court days. So just remember that that does not count weekends and court recognized holidays. One of the things we're going to talk about in a minute, though, is AB486.
Right.
Because you can now raise a defense based on your rental assistance application, but we'll get into that in a minute. I just want to make sure everybody's aware that you still need to file a tenant's affidavit to contest the eviction and raise all these defenses, whether it's the CDC moratorium, whether it's requesting mediation, or alleging an AB486 defense. And then a hearing will be set either when you file or if the landlord files, and there are certain jurisdictions that mandate that the landlord file its complaint within a certain period of time, mostly in Reno and Las Vegas. So just keep that in mind. Whether or not your hearing is scheduled at the time you file will be dependent on the jurisdiction you live in. And then mediation may delay the hearing for a period of time as well. So that's non-payment of rent. That's a 7-day notice. When you get the 7-day notice, you need to take action. For no cause notices, your landlord will first issue you a 30-day or 7-day if you pay weekly notice to vacate. This notice must advise the tenant that you have additional time, the ability to request additional time if you are 6 year over or disabled. But if you do not move out within the 30 days or request the additional time and essentially agree to move out, your landlord will then serve you with a 5-day unlawful detainer notice once that 30-day notice expires. The notice must be served pursuant to NRS 40.280, which means the licensed process server or the sheriff. And then again, you have the 5 days to move out or file a tenant's affidavit once you get that unlawful detainer notice. And again, as we're going to talk with AB 486, whether it was intended or not, AB 486 does appear to apply to no cause notices. And we'll talk about that. And again, once you file your tenant's affidavit in response to the 5-day unlawful detainer notice, whether you get a hearing when you file or after the landlord files its complaint depends on the jurisdiction you live in.
And let me just note for the record that I think, because landlords have been prevented from giving 7-day notices, they really are issuing 30-day no cause notices because the rent is late. So if we're looking for a justification for the legislature to include this is the reason, is because landlords can't serve a 7-day, so they serve a 30-day for non-payment of rent.
Right. I mean, it's basically trying to avoid application of all these laws, which should not be allowed. All right, AB 486. So it has already gone into effect. So if you do get a notice and are facing eviction and need to file a tenant's affidavit to contest that eviction, you can use AB 486 to raise a defense based on a rental assistance application. It does not apply to nuisance notices, but does specifically apply to all other evictions pursuant to NRS 40.253 and 40.254. And what those are the summary eviction statutes. 40.253 is the statute that lays out the process for summary eviction and includes non-payment of rent. 40.254 basically are all of the other reasons somebody can get evicted and allows summary eviction for other evictions. So includes no cause notices where the tenant is in default in the payment of rent. So like the other Nevada moratorium, it does require that the tenant be in default in the payment of rent, essentially what David said, that the landlord is trying to avoid the application of the moratoriums by issuing a 30-day notice instead. It also applies to mobile home lots. So if you own your mobile home and you rent mobile home space, this does apply to you as well.
And I would just point to that second bullet point of yours, Ray, that you need to apply for rent assistance. You need to sort of reach out and do that if you haven't done so already. Even if you don't think it's going to work or you don't want to go through the hassle, it's going to help you avoid an eviction. So while that application is pending and you can provide proof that you've applied for rent assistance, you will be protected from eviction. And that's the reason to do it. And it does require do some paperwork or spend some time filling out forms, but it really is going to be worth it. You might get the rent assistance, but more importantly, you'll avoid the eviction if you've applied for that rent assistance.
Right. And just to be clear, rent assistance is provided by a government entity. So just keep in mind, we had a question of whether or not this would apply to, private assistance. If you get some other type of rental assistance, it does say that it has to be provided by a governmental entity. So just keep that in mind.
Also, the COVID update today has a link to the state of Nevada, and doesn't matter if you're in Washoe County or Clark County or wherever, it provides the 3 different links to rent assistance.
And then just a final thought, as I said, the AB 486 applies to evictions under NRS 40.254, which allows summary evictions for other types of eviction notices other than non-payment of rent. I would be very hesitant if you get a lease violation notice for another reason that has nothing to do with the payment of rent. I don't believe you're going to be able to use this as a defense. So just keep in mind, it applies to no cause notices. It applies to lease violations that allege a lease violation for non-payment of rent, but probably not for other reasons.
And we don't know for sure, but I think there's some ambiguity baked into AB 486 It could be LCB not knowing landlord-tenant law, or it could be, Ray, this flexibility that you just pointed out, that if it's a lease violation for having wild parties, it's not related to the non-payment of rent, and it shouldn't be included in AB 486.
Right. But if landlords are trying to avoid giving a 7-day notice and give a 5-day notice instead, it should apply.
And if the lease violation is non-payment of rent, then obviously 486 should apply.
Right. Okay. In order to raise this is a defense to an eviction. So tenants do need to file a tenant's affidavit with the court within the time period, whether it's the 7-day pay or quit notice or the 5-day unlawful detainer notice. So there's 3 bases for defense under AB 486. That you have a pending rental assistance application that is being actively pursued, but you don't have any final decision on that notice. You do have to be actively pursuing the rental assistance. All that means is that, you know, the holdup on your application is not because of you, essentially. That it's the agency, it's the landlord, it's something that's not the tenant's fault. So there's, you know, the basic, if you apply for rental assistance and, you know, the agency hasn't processed your application yet, you can file this as a defense and essentially request that the court stay your eviction until your rental assistance is paid. If the rental assistance is paid, then the court will dismiss the eviction. But let's say you're doing everything you need to do to try to get your rental assistance application submitted, but the landlord is not cooperating or refuses to accept the rental assistance. You can also raise that as a defense to the eviction. In those circumstances, if you're able to show that the landlord is not accepting the rental assistance or not cooperating with the process, the court is supposed to deny the eviction. Landlords, though, can file a motion to contest this. So they can respond saying, no, that's all wrong, whatever it is. But be aware that if your landlord isn't cooperating, that might also provide you with the defense of the eviction. Again, this is all on the premise that the reason your rental assistance application is not going through the system is not because of you as the tenant.
I mean, your point at the bottom, like if the landlord is facing foreclosure, why would the landlord refuse rent assistance? There's some ambiguity baked into here, and obviously that defense would never work if the landlord's refusing rent assistance.
Right.
Take the rent assistance and you won't be foreclosed. Like what the hell?
Yeah. And, you know, there's a lot of ways that landlords can avoid foreclosure. So again, a realistic threat of foreclosure. I mean, I would hope that the court is interpreting that to mean like the notice of sale is about to expire. Right. And even then, like, what has the landlord done? But we won't get to that. One other thing is if you're alleging that the landlord isn't cooperating and that's why you can't get rental assistance, the court can award damages for the landlord's essentially interference with your application. I'm not sure how that's going to play out in real time, but just be aware that you can seek damages if it's the landlord's fault why you can't get rental assistance.
I mean, how realistic is that? I mean, I think if this all goes away and it's supposed to go away in June of 2023 or the state of emergency is rescinded, but, you know, in theory, you could use the damages as a defense in another non-payment eviction, but it's just, it just doesn't seem to be realistic.
Yeah, we'll have to see how it plays out. But I appreciate the sentiment that what they're trying to do is say landlords take the rental assistance. So we'll see. So in addition to being able to raise AB 486 as a defense, there is also a new process where tenants can actually allege wrongful eviction if they've been evicted after the landlord has accepted rental assistance from the government agency. So if the court finds that the landlord accepted rental assistance on behalf of the tenant and then continued to pursue or otherwise evict the tenant for any reason during that default period, the court can impose a civil penalty on the landlord. The government agency can actually file this claim with the court to try to get their money back. But the tenant can also file and get an amount up to a quarter, 25% of the rental assistance that was paid and get fees and costs paid. So again, I think the goal here is, landlords shouldn't be complaining about the moratoriums if they're refusing to accept rental assistance. So this is a way to essentially punish bad actors and disingenuous landlords that take rental assistance and then evict.
And I think the cautionary tale, the thing that one lesson we can learn is don't do things at the last minute, because there's kind of absurd sort of things that arise, like the government entity, like what government entity is going to pursue this? It's not going to happen. Why they included it, I don't know, but it's kind of foolish to include a government agency like they're going to do anything about it.
Right. But, you know, for government waste and abuse, this is a way to recoup money the government gave to landlords that then evicted tenants. So
that might be a False Claims Act violation.
no, that would be interesting.
They're state and federal. So if it's state money, then they violated the law. If it's federal money, they violated the law. They're not supposed to evict if they accept the rent assistance.
Right. So this is essentially, I know there were a lot of judges were already basically saying this, that if the tenant was going to get rental assistance, the landlord basically not only couldn't refuse it, but then couldn't evict the tenant. I think that was happening in practice. So this just kind of solidifies that landlords cannot evict tenants after getting the government rent assistance. But as we have said, there is still rental assistance available. David said in his COVID update, which I will try to link in the video replay, possibly, we'll see. But essentially, these are the individual links to the government assistance websites. But David's COVID update from today, which is on our YouTube channel, has a link to one website, which has the information, correct?
I think it's the housing division that really wants to take control over this program and be the go-to sort of government agency. And if you just go, that they will have Clark County, Washoe County, and rural Nevada, and probably all those links that you pointed out.
Okay, somebody says that there is not a link. I'll also link it down in this video's description box, but it's from David's COVID update from this morning.
Because I was advertising this live stream because it's me and I like to promote myself.
As we all should. But I will go ahead and link all of these links and the link that David put in the COVID update in the description box for this, this video as well. But we can hang out for another minute if you guys have any other questions or would like us to address anything else related to the moratorium or AB486. But we will be back the second Thursday of July for another edition of Nevada Legal Services Now. I think that's after the Thursday after the 4th of July, right?
Yes, July 8th, from what
July
I can see, although the lights are really bright. Do you have another slide, by the way?
I think it's just, our context slide. So we do have a question. What about tenants who are already evicted and don't have a home and the landlord's got rental assistance? Yes. So that's that process we just talked about at the end. You can file a complaint for wrongful eviction against your landlord. That you can then get an amount equal to 25% of the rental assistance paid and get all of your costs and fees paid. So it's not really a process to get back in, although I would definitely, you can probably file a separate action for a motion to set aside the eviction. You can do both at the same time. I don't see any reason why you couldn't do that, where you can ask the court to set aside the eviction and let you back in. Now, whether or not the court does that is going to depend on whether there's a new tenant in the unit. If there's a new tenant, I doubt that that's going to happen. They're probably just going to consider the monetary damage. But you can include this new claim for wrongful eviction and potentially a request to set aside the eviction order and be restored to possession of the premises. So that is this new process where the court can award you money equal to 25% of the total rental assistance paid if the landlord evicted you after getting rental assistance.
Ray, I don't want to ask you a question that maybe you don't know, but is this similar to a complaint for expedited relief? Is this? Yes,
I would. That's kind of what I was assuming that this would be like. You know, there's probably not a form for this anywhere right now. I know we have not developed one ourselves. But I would treat it like a verified complaint, for sure.
But you might not want to just sort of use the complaint for expedited relief that's in the self-help center here in Clark County.
Right, and model it off of
Right.
that. Yeah, absolutely. All right, well, thank you guys for attending and watching our video. We appreciate it. Again, as always, if you have any suggestions for other material or other questions that you would like us to answer, we're always looking for topics for our YouTube videos. And let us know if you have any other questions or topics that you would like us to deal with. Oh, we got another question.
Okay.
I've been hearing that the CDC protections are having very, very minimal effect in Nevada. Is that what you were seeing too? Why is that? That's actually not what I've been seeing. We've been filing a lot of defenses based on the moratoriums and submitting CDC declarations for tenants. So I'm not really sure totally what the effect is, but through the whole process when the moratorium started, we have been assisting tenants avoid eviction, essentially based on the moratorium. Now, we did say that there was an issue with the courts interpreting the CDC moratorium as not applying to no cause notices. So if the tenant is self-represented and doesn't have an attorney with them, whether they can articulate that argument and get a judge to agree. In some courts, I mean, this is not all courts, for sure. Some courts have been evicting tenants on no cause notices. But David, did you have?
Yeah, no, I think Hearing Master Brown does recognize the CDC moratorium for 7 days.
So does Reno, yeah.
Right. So, in the major jurisdictions, it's recognized and it works. Maybe in some of the outlying areas, it doesn't. By outlying areas, I mean like Northwest Vegas.
Yeah. As Sparks. So that, I guess that would be our experience that, and the Sparks court actually stayed a bunch of evictions when the CDC moratorium was first enacted. And they, basically if the tenant raised that as a offense, it was almost automatically stayed. So courts like Sparks are also recognizing that. Whether or not they recognize it for no cause notices now, who knows?
Right.
But no, you would file, we're back to talking about the AB486 complaint. You would file that with the court. You can contact us if you would like to see if you qualify for our assistance to do that, to help you with that process. But right now you need to file that complaint for wrongful eviction with the justice court that evicted you. All righty. Thank you, David.
Thank you, Ray.
And we will see you guys on July 8th. Have a good day.